Howdy, my name's Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas, and I represent folks who've been accused of a crime in Houston, Conroe, the Woodlands, and that general surrounding area. Today we're going to continue our series on the dirty little secret of criminal law, and today's topic is going to be assault, family violence that is enhanced by an allegation of impeding breath or blood flow, also known as strangulation. So has there always been a strangulation assault case on the books? The answer to that is no. For many years, if the case was not serious enough to rise to believing that the person had used a deadly weapon, mainly their hands, if it wasn't that serious, then a strangulation case where someone had their breath impeded for a short time and it caused pain, but that was it, that would have been a Class A misdemeanor with a maximum punishment of 365 days and a $4,000 fine. Since the legislature changed the law to allow for this new offense, the punishment range has gone up significantly. It's now a third-degree felony for any allegation that breath was impeded. There's no time limit or restriction. It doesn't mean that, impeded breathing for more than 30 seconds, impeded blood flow to the head for more than 10 seconds. It's any amount of time. If the breath was impeded for any amount of time, technically this law would say that a person could be found guilty. So who can be charged with assault strangulation? Well, it's anybody who's in the family, in a dating relationship, or a household relationship. So that means roommates in college. If one strangles the other for some reason, that could be listed as a third-degree felony. Dating relationships are where this comes up the most. Most of the time, it's just an argument that has gotten out of hand, and maybe there's an allegation that force was applied to the neck. One thing I see a lot is that people say they were held up against the wall with this part of someone's arm on their throat, and that it wasn't like a grabbing around the neck like this and an intentional strangulation. And so this offense is something that they could charge any of those things with, even a momentary strangulation. But there's some specific language they'd have to prove. You cannot be convicted of this crime unless you impeded the normal breathing or circulation of blood by a specific act. And those specific acts are two different ways. Applying pressure to the neck or throat, or by covering the nose or mouth. So suffocation, like if you put a pillow over someone's face and they can't breathe, that would technically be part of this too. There is this other little requirement that there be an experience of pain. So if you were to put a pillow over someone's mouth or nose and it impeded their breath, but it didn't cause any pain at all, then I would say technically this statute wouldn't apply, because it's only when you have a regular assault bodily injury plus the strangulation. I know there was a case that was on appeal. The defendant was convicted of both the underlying offense and the strangulation offense, and the appellate court said that that was double jeopardy because the offense of strangulation actually required proof of the element of injury or pain. So what about self-defense? Well, there is no provision of the penal code that says you cannot restrict someone's breath or blood in self-defense. It's something that may happen just tangentially from other methods of restraint when you're trying to control somebody who is acting crazy, who is being totally belligerent and coming at you. You can definitely see where somebody holding you in like a bear hug, or having to put some other type of hold or restraint on you, would potentially limit someone's breathing or blood flow. Sleeper holds are designed to subdue somebody, and they're used in all sorts of MMA fighting and things like that. It's a method of restraining the other person when they serve as an immediate threat to you. And that's really what the law is going to look at, is what was the proportionality of what happened to you or what was imminently going to happen to you versus what you did. And that is how the law is going to be applied both by the judge or the jury. So what is the dirty little secret about assault family member strangulation cases? Most of it is that they are not prosecuted all the way to a third-degree felony conviction most of the time. A family violence case is a family case, and it has a lot of twists and turns, and there's a lot of emotions involved on everybody's part. And so many times there may be an affidavit of non-prosecution, which makes the case a little bit weaker for the state. And sometimes the prosecution will look at that and say, well, maybe we'll plead this down to a misdemeanor. Is the defendant interested in taking a misdemeanor conviction on this? That's something that can be a good remedy so that you're not facing prison time. But it could also be a problem because any conviction for family violence can be used to enhance a future case to that same third-degree level, and you'd be right back where you started. So it's important to have a lawyer who can advise you on what's right for your case, what the evidence looks like in your case, and whether or not those options that a prosecutor tries to give you are really what's best for you.